views and opinions expressed in this program are those of the participants and do not necessarily reflect the views of BronxNet or the program underwriters.
All right, well, coming up on this edition of Today's Verdict, we are all too familiar with that dreaded termination letter, the one that politely tells you that you are no longer welcome at your place of employ. But did you know that when you are fired, you still have rights as a former employee? And have you been involved in a child custody battle? It's a long process that we will discuss later in the show. Employee rights upon termination and child custody issues coming up right now on this week's Today's Verdict. Hello, and welcome to Today's Verdict, the live and interactive show that gives you your legal rights and options. I'm your host and trial attorney, David Lashwell. Today's Verdict is always encouraging you to stay connected. Make sure to tweet us at Today's Verdict and hashtag Ask Today's Verdict if you have a question. Also, make sure to like us and follow us on Facebook at Today's Verdict, and check us out at BronxNet.tv/RoxLegal. And last, but certainly not least, don't forget to tweet me at David Lashwell. An employee who was terminated by their employer still has the opportunity to receive many benefits even after his or her job loss. Benefits include health coverage, your final paycheck, and much more. Joining us today to help get us a better understanding on the topic is employment and civil rights attorney Daniela Nanau. Daniela, thanks for being here.
Thank you for having me, David. It's
a
pleasure.
Well, it's never fun getting a termination letter. Let's first talk about some of the reasons that you cannot be fired for, some of the wrongful termination instances. Give me a few.
Okay, so in New York State, most of us are at-will employees if we don't have an employment contract with a specific term. And if we're at-will employees, it means we serve at the pleasure of our employer, and we can be fired for no reason or any reason at any time.
So if your employer just has a bad dream about you one night and comes in the next morning and says, look, it's been nice having you here, but I don't want you here anymore, that's perfectly okay.
Well, it's okay. I guess it depends what kind of dream, right? Because there is such a thing called wrongful termination in New York State, but it's a really narrow definition, and it follows our civil rights laws. We have federal, state, and local civil rights laws that protect us from discrimination because of protected characteristics.
Give me some of the categories that would be wrongful termination.
Okay, so if you're fired because of your age, if you're over 40 years old and your employer thinks that you're just too old, that's age discrimination. If you're fired because of your gender, if you're fired because of your religion, because of your national origin, because of your color, these are all prohibited reasons to terminate someone's employment.
And it doesn't matter whether you're an employee will or not. If you're fired for one of those reasons, you definitely have been wrongfully terminated.
That's correct. And also, if you complain about discriminatory conduct or treatment and you're fired because you complained about it, that also is also illegal.
Now, when we say employee at will, that means there's no employment contract.
Correct.
But what if there was an oral agreement between yourself and your employer? Can there still be a contract there?
Well, I've honestly never had that kind of a case, but oral contracts are enforced in New York State, so ostensibly that could be the premise of a contractual employment relationship.
All right, so moving along, you get the bad news, you get the pink slip.
Yep.
Do you have a right to clear out your desk? Do you have a right to take what's on your computer with you? What can you do the minute you find out that while you're in your office that you've been let go?
It really depends. Most of my clients, they receive notice of their termination of employment in the context of a meeting with HR. If they are protesting the termination of employment or what has been discussed in the meeting, maybe they will be escorted out of the building and they won't have an opportunity to even clear their desk. But the contents of their desk, if that is their possessions, they should be able to get those possessions back, or it's conversion, which is stealing.
All right, but what belongs to the company, which might be patents or anything that's on a computer,
That's right.
emails.
Work product could be the company's property. It could contain confidential business information. You don't want to take that with you because that could create a claim that the company could have against you for stealing their business secrets.
And we always hear of stories of companies that actually escort you out of the building.
It happens all the time.
And that's allowed.
It is allowed. I would say that, no one has the right to injure someone on the way out. No one has the right to threaten or intimidate someone to remove them from a public setting.
So they can't grab you by the arm and take you out. They can't put you in handcuffs and take you out.
That's right.
They just
But they
escort you out.
they can remove you from the premises.
They
That's
can.
correct.
So if you don't want to go and they've given you your pink slip, they can actually have security pick you up and take you out of the office?
Yes, because it's not, you don't have any specific right to be in your employer's place of business unless you have a stated reason to be there. And if you are no longer employed with the company, then they do have the right to remove you from the premises. But like I said, it cannot, it can't be with force.
Okay, let's talk about your right to get paid. Sometimes people are paid, bi-weekly at the end of the month, maybe on a Friday. Let's say you're terminated on a Wednesday. Can you get your money immediately? Do you have to wait till Friday? How does it usually work in terms of pay?
Generally, you have to wait until the pay period ends, and then you will be paid. But you are entitled to get pay for every hour worked, and that includes overtime pay or some other type of premium pay.
I want to talk a little about overtime because there are a lot of viewers who do write in and seem to suggest that there doesn't seem to be a fair system in terms of documenting exactly what is overtime and what is not overtime. Am I correct?
There is a huge problem with legal payments made to employees. I represent many, many employees who have not been paid legal wages. There's a specific minimum wage for New York State, which is right now $9 an hour. If you work over 40 hours a week, you are entitled to time and a half. If you work 10 or more hours in New York State, you're also entitled to premium pay. And you are, not only does New York State, but also the federal law ensures that you as an employee have a right to payment. And if you don't get paid, my suggestion would be to your viewers that they should consult with an attorney because federal judges, which is where I litigate most of these claims, understand this very basic concept that if you do the work, you have a right to be paid. And so those cases are successful and go quickly.
So Daniela, when we're talking about wrongful termination or we're talking about a failure to pay wages, whether it's overtime or whatever it is it only brought in federal court? Can it be brought in state court? Can you do them in both? How does it usually work?
So we have federal, state, and even a New York City human rights law that affords us with certain rights and protections in the workplace. You can litigate these claims in federal court. You can also litigate them in state court. If you want to go to federal court, the gatekeeper is the U.S. Equal Employment Opportunity Commission. You have to go there first. They have an opportunity to investigate your claim for 180 days, and if they determine that you have probable cause that discrimination occurred, or even if they didn't complete the investigation, you get what's called a right to sue letter, which you need to go to federal court. There are no prerequisites for state court. You can walk into state court at any time within a 3-year time period, which is the statute of limitations. That's right, and you can litigate your case. And in New York City, we also have the New York City Commission on Human Rights, where you can also litigate cases now. We have a new commissioner there, Carmellen, who is very active. She has an amazing team, and I have also brought cases there to litigate.
So let's say you get your back pay. Everything's so far so good, and you're also entitled to severance. What is severance?
Okay, so in New York State, there is no statute that gives an employee a right to severance, but there could be an agreement with the company and its employees that at the end of your tenure there, whether they decide or sometimes you can decide, there will be a severance benefit. Sometimes it's outlined in an employment agreement, sometimes it's outlined even in a handbook, and you get some kind of payment as to at the end of your employment term.
Well, what if others in the company are getting severance, but you were not promised severance? Can you still make that same claim if somebody else is doing the same job duties that you're doing? And you're saying, well, what about me? I want severance too. Does that matter, or can you equate the two?
Severance is not something that can be decided on employee by employee basis. If severance is afforded to everyone as an employee benefit, it is actually considered an employee benefit plan, much like a pension plan. And so you cannot deprive specific individuals of it as an employer. So everyone gets severance or no one gets severance.
And by the way, a lot of times when you get severance, you're giving up your right to bring an action against the company, so you have to make sure you understand
that may well happen
what you're doing when in terms of severance. Moving along, there are other things that you may get as a employee who's been terminated. What about health insurance?
So you are entitled under COBRA to have the same coverage. Really, it's a matter of who's going to pay. Generally, the employee pays, but sometimes the employer picks up the cost of COBRA. And COBRA is only something that is available to terminated employees for a specific amount of time,
Which is for
12 to 18 months.
Can you get that extended past the 18 months, or that's it?
No, that's it. Then you have to move on to another plan.
Another plan. But at least we know from 12 to 18 months you can usually...
That's right, which helps a lot of employees because they want to stay on the same health plan because they have relationships with doctors that are not so easily changed.
Does there have to be a certain amount of people at the company to be able to get the health insurance? In other words, do you need a big company to be able to get under COBRA? What if my own employees left, and let's say I only had 2 or 3 employees? Would I still have to offer health insurance for the year? I would have to do that.
Yes, and they're eligible for COBRA.
Wow. Okay, this topic of wrongful termination seems to be one of those topics that are flooding the courthouses. I know you practice in Queens, throughout the city as well. Is there a particular area of the law that jurors seem to really be more sympathetic with than others? Sexual discrimination claims, wage and hour claims. Is there something that you see more often than not that juries really are grabbing onto this and saying, hey, that's not what we're going to do here in this county?
I think that wage and hour claims are very easy for a jury to understand. It's very easy to be able to put your shoes, put yourself rather in the shoes of a plaintiff who has worked very hard and has not gotten his or her legal wage. And the proof of that is very simple. Oftentimes employers who don't pay legal wages don't have any records of payment. And so these are very easy cases to prove.
By the way, and lastly, unemployment insurance. Yeah. You get unemployment too, right? How long does that last for?
Generally 26 weeks. You have to apply for it through the state. Generally, one cannot quit a job and then apply for unemployment insurance. Generally, you have to be let go or fired.
Where do we find you?
I'm on the internet, DanielleInanow.com.
All right, and you're going to come back and we can
absolutely
do a rundown maybe in 6 months.
That would be great. Thank you so much, David.
All right, well, we have to take a quick break, but don't worry, we'll be back with more Today's Verdict right after this.
They said a bottle was just a bottle. That no one would ever notice me. But I knew I could be more. That one day, I would make people smile.
There's a shelter pet who wants to meet you. Meet one today. Visit theshelterpetproject.org. Adopt.
Adopting a new pet is a rewarding experience. And shelter pets make super pets. Your new best friend will steal your heart, bring you happiness, and enrich your life for years to come. You can make a difference in the life of an animal. Adopt and bring home a shelter pet today. To find out more, visit theshelterpetproject.org.
Hey, I'm Darren Jaime. I'm the host of Wednesdays Open right here on BronxNet Television, Channel 67, and also on Verizon Files, Channel 33. Want to invite you every Wednesday. You get an opportunity to see what's going on in the world of news, current events, debates, public information. That's what happens here on Open every Wednesday. So we invite you to join us right here on BronxNet Television.
Hello, good people of the Bronx and beyond. Welcome to A Life in Art.
Wow, these are really good.
You act surprised. Practice makes perfect.
You don't have to be perfect to be a perfect parent. There are thousands of teens in foster care who don't need perfection. They need you.
Welcome back to Today's Verdict. I'm your host, David Lesh. We are always encouraging you to stay connected. Tweet us at Today's Verdict. Well, going through a divorce is difficult enough, but when the issue of custody comes into play, things can go south very quickly. Well, here to tell us what you as a parent needs to know to protect your parental rights is family law attorney Jessica Quadrado. Jessica, thanks for being here.
Thank you for having me.
Yes, divorce, it's tough. And it's even harder when there are children involved. Child custody is a difficult area of the law, and I know that you know so much about it. What are the different types of custody, just generally for the viewers, really?
Okay, so we have in New York sole custody, and we have what's called joint custody. The difference is with sole custody, there's a custodial parent, the one that primarily takes care of the child, makes the everyday decisions for the child. That's where the child's going to reside, with that parent. The other parent then becomes the non-custodial parent.
A visiting parent.
Or, that's right,
Or the
parenting time we call it now.
Parenting time, okay.
Right. So when it comes to joint legal custody, it's just that. It's legal decisions that are made between both parties. In that area, really what you're looking at is both parents making joint legal decisions when it comes to religion, medical, and education. Those are the three big issues where you're going to want to have joint legal decisions on. So the non-custodial parent can have joint legal custody. They're just not going to be the primary caretakers. They're not going to be the ones living with the child. They're not going to be the ones making the everyday, day-to-day decisions for that child.
So there's really a difference between living with a particular parent and making the decisions for and the decisions made for the child. So you could have both parents making all the decisions, yet one particular parent is really the one who is living with the child. Is that the take on it?
One parent will live with the child. That would become the sole custodian parent.
All right. Let's say that it's joint, all right? And because when I was younger, generally the way it worked was the mom would have sole custody, or the child lived with the mom, and every other weekend the child would end up going to the dad, right?
Right.
But that's not the way it really is anymore. More often than not, there's shared or joint custody where there's 3 nights in one parent, 4 nights in the other. Does that seem to happen or not really?
The confusion lies where, what does joint mean? Joint in New York does not mean we're sharing 50-50% of the time. In New York, we only use the word joint to mean that you have joint legal custody, that you're sharing in the decision makings of those three areas that I discussed: religion, education, and medical. But the child still would live with the primary custodial parent.
I understand. All right, so let's say the parents are not getting along, and at the very onset, they want to have some type of agreement as to where the child is going to go, where the child is going to live. Does the court get involved immediately? Is there some other way? How do the two parents begin the process?
Right. So when you're living together with a child, you really don't have a situation where you would need custody, because you would both have what we would say custody without any particular order in place, because you're both living with the child. Once you separate, the moment you separate, either parent can go to court the very next day, or you could work it out between yourselves, or you could wait a year later. There's really no time frame as to when one has to go to court and ask for custody papers.
Let's say it can't be worked out, which is 9 times out of 10.
Okay.
What's the next step?
So there are 2 routes that you can go to obtain custody. If you're married, for example, there are 2 routes. You can go towards the matrimonial action, and you can file a matrimonial action seeking a divorce and also seeking custody of your child. Or you can go towards family court. Family court, you can be married. You don't necessarily have to be married. So if you go through family court, for example, the first thing you would do is file a petition for custody. The other parent will be served. They would have to come to court, and they would try to work things out.
Do most people do this on their own? Do they bring an attorney with them? With respect to your experience,
it works both ways. Oftentimes, litigants will consult with attorneys prior to filing a divorce action or going to family court, or they'll just directly just go right to family court and just file a petition on their own, and then feel that they may need an attorney, and at that point, the judge will adjourn a case to allow them to have an attorney present.
Okay, so now let's say the parents are still not getting along, and they're in the courtroom. I'm sure this happens often. When does an attorney for the child come into play? Is there a guardian ad litem or somebody else appointed to help ease the process?
Right. So, best case scenario is that the parents agree and everything works out on day one.
But that doesn't happen, Jessica.
That does not happen. So depending on the child's age, usually if the child is a verbal child, which means that the child can talk, is of talking age, what we call a verbal child, that child will be appointed what is known as their own attorney, or an attorney for the child. That attorney will speak to the child privately and get the wishes of the child, and they become then the advocate, so that child does not have to go to court. That's what we usually like to avoid, is having the children come to court and be thrust into the middle of this battle of custody.
You know, way back when I was in law school, it was always the best interest of the child, the BIC,
Still
B-I-C.
is.
It still is, am I correct?
That's correct.
And how does a judge figure this out in terms of custody issues? What factors come into play, really?
Well, so there are numerous factors, and not every single factor goes into play. There's factors such as the parent's health, which parent is in better health, residency, which parent has room for their child or their children at that moment, stability, who's constantly moving and who's staying in place.
So Brad and Angelina, all right, let's put those two together, okay? They both have funds, they both have a lot of property.
Sure.
What would a court be looking at there, let's say?
Well, I really don't know what the
I know
issue
you don't
is
know
going on there.
Angelina or Brad, but I assume
the media, in that situation, the media is stating that there are some possible drug use by Brad, for example.
They would look at that. They would look at drug
absolutely.
use of a particular parent.
Drug and
obviously.
alcohol use is a factor that goes into play for best interest, absolutely.
All right, now we have an order.
And child abuse, which is another issue for Brad.
Okay, now we have an order. Let's say the judge issues an order and grants custody. What about grandparents? Do grandparents have a right to visit?
So the judge would have to determine whether or not they have standing first. Once they have accomplished that, it's a two-pronged test, right? So once the grandparent does have standing, then the judge tends to look at, well, what is the connection this child has to the grandparent, first and foremost? Is it a strong connection? Was this child seeing or acting, for example, as the custodian for this child? And why is this grandparent now not able to see their child? What is the parent doing? Why is the parent blocking access? So the judge has to look at all those factors to determine whether they can have visitation.
By the way, do other states give credence to our own orders in New York? In other words, let's say the child goes to visit a grandparent in Florida, but isn't allowed to go. Does a Florida judge do something to make sure the child gets back, or how does it usually work?
If there's an interstate issue, usually the parent that has encountered the problem would file, in that example, in New York, because New York is where the jurisdiction lies for that particular child. That child just went over there on vacation, supposedly, and really their residence is in New York. So New York would retain jurisdiction.
Right.
A Florida judge can entertain a motion. They would give full faith and credit to any orders of New York. That judge usually would call a New York judge. The Florida judge would call a New York judge to see what the situation is, to see if the Florida judge needs to obtain, for example, emergency jurisdictions, because sometimes there's more to the story than we really know.
Are there any tips you would give anyone who's watching right now in terms of custody, things you would tell them to do before they do anything else? Writing things down, taking notes about their own relationship with the child or maybe the spouse? Is there anything that you would say, certainly somebody comes in to see you for the first time?
Sure. Usually when there's situations where there are interstate, one parent wants to move to another state for financial reasons and they're splitting. In that situation, I would say run to court right away. You want to be able to get custody papers to have that child remain in the state of New York. Should the other parent, the non-custodial parent at that point, take the child out of state, if you've already obtained custody, because you ran to court and you got a custodier, if you've already obtained custody, you can run into a New York court and ask a judge to issue what's called a writ.
Unfortunately, that's all the time we have. But you're going to come back?
I will.
All right, well, don't go anywhere. Well, that's all the time we have for today. I'd like to thank our guests for joining us, and of course you, the viewers, for watching. If you missed any part of today's show, be sure to check us out at www.bronxnet.tv. Also remember, if there's a legal issue or topic you would like to see on a future edition of Today's Verdict, feel free to contact me at davidlesh@bronxnet.org or tweet us at Today's Verdict, and make sure to hashtag Ask Today's Verdict. For myself and all of us at Today's Verdict, always remember, know your rights, know your issues, reach a verdict. I'm David Lesh. We will see you again in 2 weeks with an all-new episode of Today's Verdict right here on BronxNet. Take care. And if I can get my son out here, he can say hello to everybody. Come on, come out here. Give a quick hello. Come up here, up here, up here, up here. So good looking. All right, you have a good time?
Yes.
All right. Future lawyer. Good night, everybody.